Going live. What's up, perps? I'm still getting tabs together and stuff, but I got a couple kind of interesting things to go over. That's not what I saved. It's not. Hold on. I have to dig something up real fast. I'm gonna have to dig it up. Custom date range. Look at this. I'm gonna run that back to 2018. You dirty. Oh crap! I changed the wrong damn date. Alpha Life, what's up, my brother? I want to go. Let's say 18. Let me listen to this real quick. Make sure it's what I want. Alpha Life, how you doing, brother? How you and the wife and kiddo doing?
Can you button up my shirt?
No, find you another shirt, little girl.
Why?
Because that's a sweater, not a shirt. Let me make sure. Good deal, brother. Yeah, that's the other one that I want. So there's a couple of different cases we're going to play around with. Let me slide that over there. Oh, good deal, man. All right, let's see. Give it a few minutes. Wait for people to jump in, and then we'll get this rolling. So, Alpha, you up in New York, aren't you? All this is going to be about Illinois and their FOID card, which is insane. But hey, what can I say? I don't make the rules. If I made the rules, there'd be machine gun vending machines. Oh, you're in VA, man. For some reason, I was thinking you was up in New York, man. Virginia's another state, man. I've been there a couple of times. Beautiful state. Just has way too many morons in it, aka politicians. Then maybe that's what it was. I was thinking you were from NY. Now, your wife, or your beautiful wife, she's from Jamaica, isn't she? That's a place I'd love to go to. You posting all that video about being in Jamaica and shit like that, man. That's some beautiful, beautiful water, beautiful people. All right, we got a few more streaming in. Yeah, me typing. Okay, yeah. Let's see what else we got running in. Yeah, I'm gonna get my stuff straight in a minute, and then we're gonna let's do some FOID card cases. Just because this whole FOID card situation is just insane in the first place. Firearms owner identification card. Why the hell do I need an extra card when I'm already going to have to get background checks run You're going to have my ID, but you feel like you got to stick me with some freaking FOIA. I was going to listen to the older case first, but I think we're going to listen to the newer case first. The newer case has to do with FOIA and the FOID cards. And I've got to look through that case, but I know that it happened just in the last couple of days, thanks to Mr. Warsaw. Warsaw Patriot sent me the information on it. Which depends on if he's working or not. We'll see. But as usual, we got to play the intro. We got to hit the Blazing Saddles up, because that's one of the funniest movies that has ever been made. I wish YouTube would let us watch it. All right, so I think I've got my stuff set. I think. Pretty damn sure. And who knows where we'll go from there. If my computer will wake up. All right, we playing the intro, baby.
Sparta!
Hey, boys! Look what I got here!
The wife took back the phone.
Hey, where are the white women at?
Man, I love that intro Swamp Dog did for me. All right, so let's see. I'm going to have to do this through screen shares because it's not letting me download the file like I want. Oh, now which one was it? Because they both come up the same. Is this one it? Nope, that's March 16th. This one's it. All right, so this is one about FOID cards, FOIA requests, sex, lies, and videotapes, and all that shit.
Hi.
What are you doing, monster?
Hug.
Hey, baby.
Why does it not show me?
Huh? Because that's lagging behind that.
Oh.
So there's always a minute or two. Wait. Go find you another shirt.
No.
My child. I like this one. Running around in a damn sweater. Sam, what is up, my brother? So let's see. Let's kick this off. So this was argued yesterday. So we're gonna listen to this. Should crank up.
The next case on the call.
You guys just let me know you can hear everything, okay?
14, number 128275. Sandra Hart et al. Versus the Illinois State Police. Counsel for the appellant, are you prepared to?
Man, about the same old saying here, Sam. Just living the dream, brother. Just living the dream.
May it please the court, I am Valerie Quinn here on behalf of the Illinois State Police.
Of course you are.
I would like to begin by discussing the plain language of Section 7.5b of the Freedom of Information Act, what it means, and how a person can get a copy of their own personal documents without making a FOIA demand. I would also like to discuss why FOIA is the wrong tool for obtaining copies of these private documents.
These people would take away your FOIA card and wouldn't tell you why.
Exception to the Act's plain terms. Finally, I'll briefly touch on the permanent injunction in this case that prohibits.
And of course, if you don't have your FOIA card there, you can't have your guns.
The language in Section 7.5b is plain. It unambiguously prohibits the disclosure of people's FOID card information without exception. And it is clear that the General Assembly did not intend to include an exception of any kind in that prohibition, because not only in the same provision, but in the very same sentence, the General Assembly explicitly allowed for an exception for information of applicants for a concealed carry license. Under the basic principles of statutory construction, that omission has meaning.
So yeah, you can't request anything about your FOID card status or information for the revocation. None of that. Oh, that's awful nice. What's up, Fire Otter? What's up, brother?
And that clear, unequivocal language should have been the end of the inquiry. The inquiry should have ended not only because the provision's language is so exceptionally clear, but because, as I
Warsaw, what's up, brother? You at work or you at the house?
In Mr. Burgess's case, that the way to get a
This is the FOID card stuff.
application or denial letter is not by making a FOIA demand of ISP's FOIA officer, but to contact the Firearms Services Bureau directly. No one is trying to keep people's personal applications and denial letters a secret.
Yeah, right.
The Firearms Services Bureau needs to be able to verify that you are who you say you are before releasing copies of your confidential info. And so the Bureau will ask people to provide proof of identity, which includes date of birth and social security number or driver's license number. But Mr. Burgess never contacted the Firearms Services Bureau in this case. And we know that he did not, based on counsel's representation during the circuit court hearing. Ms. Hart's record indicates that she submitted a FOIA demand letter with no identifying information in it. In fact, if she made an inquiry of Firearms Services Bureau prior to issuing her FOIA demand, nothing in her record bears that out. And one would think,
Gizzard, what's up, my brother?
That a person who
Yeah, all that stuff with AWB is it's absolutely retarded, but man, it's what we're.
At a minimum in your complaint.
It's going to be having.
It is
Well,
necessary to prove that
it's going to be a long time before it's over. Put it that way.
Because application and denial letters are not public documents. They both contain confidential information.
Yeah, there's vagueness, Fifth Amendment. They're running through the ringer because how they're violating
people apply for
a ton of your rights.
Unemployment benefits,
What the-
Medicaid.
Why you got the big Band-Aid on
or
that?
FOID card on the assumption
It was
the
coming
reason
off, so I had to just
that
pop
their
Band-Aid,
private,
pop Band-Aid.
closely held
Hang it on
information
your
is
wall.
not gonna
You
be
want me to hang it up in
disclosed to
here?
anybody but the
Yeah.
government officials who are
So I think they
responsible
can
for
see
making a
it.
decision on those documents.
All right,
I know
well, right now, sit it up on my table.
With a FOIA request.
No, just set it up on my table.
Don't have to provide that level.
We'll have to take care of that
They
later.
do not, Your Honor. You don't have to. prove
Yeah,
that
October
you
11th and
are
November
when
12th.
You make a FOIA request.
Yeah, I looked through those
You don't
dates you
even
sent
have
me.
to give your real name, and people have made FOIA requests under using pseudonyms. But if the
Hungry,
information
hungry.
is truly public, then it doesn't
Munchkin,
matter.
hungry.
It's anybody's entitled to it.
Munchkin hungry. Can
Any person
Munchkin
who
have a
asks
bowl
for it
of
is entitled to it.
Can have a bowl of what?
chip?
In this instance, they had provided
A bowl of chips.
proof along with their
Munchkin hungry.
of identification. Your position would still be.
How about you look in the pantry and see whether you want like some beefaroni or something like that?
Provide it to them because, well, and neither, of course, these plaintiffs did provide identifying information.
Right there.
FOIA is the right place to do that. The FOIA officer responds to FOIA demands. And if, in this case, according to the plain language of 7.5B, no matter what kind of identifying information was in that FOIA demand, disclosure was prohibited.
Well, let's assume that accurate identification information is provided. Let's just assume that. Is it your position that then it would be appropriate to comply with the FOIA request?
It would not be appropriate to release it through FOIA, Your Honor. You would have to go to the Firearms Services Bureau. FOIA says, under FOIA, using FOIA as the tool, you cannot release that information. But it's easy enough to get it elsewhere. FOIA is the wrong tool.
I understand what you're saying, but what I'm trying to get at is, are you arguing that in addition to that problem, the plain language of the statute prohibits the disclosure and also the court order?
We're talking about the permanent injunction in this case? Oh, yes. I mean, it's almost a belt and suspenders that there's the provision of 7.5B, and then there's the permanent injunction that prohibits disclosure to anyone.
So providing the identifying information, who you are, who you say you are, really doesn't solve the question, right?
People can get, if people go to the Firearms Services Bureau and ask for their own copies of their own documents, they can get copies of their own documents. The conundrum is you don't want
Yeah,
to
to
use
Alpha.
information
You're exactly right.
and when anybody can make a FOIA request, ISP has to satisfy itself that the person who's asking for it is the person to whom it belongs. I do not believe the permanent injunction could be read to say that somebody can't get a copy of their own documents from the Firearms Services Bureau. That was more addressing the fact that the Associated Press back in that day had made a request for the names and the expiration dates of people's FOID cards, and the public access counselor at that time looked at the law as it was.
Yeah, Thomas Magg's arguing this too.
7.5E, and determined that that information could be released. So,
And the older case we're going to listen to is Brown, and that was about.
Wanted that injunction in place.
I believe it was a woman having a firearm in her
But I
house.
don't believe anything in the injunction says
She didn't have a FOID card, and they wanted to throw her ass in prison.
Counsel, just so I understand, the crux of your argument is that FOIA is the wrong vehicle for seeking this information, regardless of whether you're accompanying that request by identifying information, saying that you're truly who you say you are. Under no circumstances is this information producible, for lack of a better word, under FOIA. Is that your argument?
According to 7.5B's plain terms, Your Honor.
Counsel, I have
Yes.
a question. When you said that they go to the Firearms Services Bureau and provide proof of identity, is the release to them automatic?
Yes, that's my understanding.
Yeah, if you can get in touch with them.
Headquarters in Springfield, take your driver's license. I think they even have a kiosk in the foyer, in the lobby area that's staffed from.
Okay, so dude, I'd watched one of Freedom Steele's videos already. I don't know whether I got to the second one you sent me. But this is okay. You can drive to the office and get information. Okay, Illinois is a big ass fucking state. So you're telling me if I live 3.5 hours away from this branch, instead of being able to get in touch with them in the age of technology like we have now, instead of just being able to get in touch with them or request my information, I got to drive down and go to their fucking kiosk? Are you shitting me?
From 8:30 to 4:30 every day. If someone
G23, what's up, brother?
They could get copies of their own documents. FOIA is it's unnecessary.
G23, do you have any links for video of them on any of that?
So given the content of those documents, ISP needs to be sure it's not.
Because if
handing
you
over
got
anybody's
video or
private
audio on
personnel
any of that,
and on the
we need to cover
statutorily
it.
protected information over to a would-be burglar, stalker, a vengeful ex, or an identity thief. FOIA is directed at public, not private records, and by its terms states that public records are available to anyone who asks for them. FOIA is for monitoring what the government is up to, not for keeping tabs on what its private citizens are doing. And not only is there no
good
need to
deal.
keep your identity in FOIA, but there's
Can
no
you
private
email?
way for ISP
Yeah,
or
it's-
any other public body. for
If
that
there's
matter,
video to
to
watch for that
ascertain who
dude,
you are
we
and
need
still
to
comply
watch
with the
it.
act. The act has a turnaround time of
'cause-
5 days. It's really not enough if someone
You know how it is with us.
provides a letter like
We do
that,
love the pain.
or in the records in this case, for someone for the agency to come back and say, okay, who are you? We need more information. With that 5-day turnaround time, it's very likely that will be treated as a denial, and there will be litigation. I would like to add, Your Honors. that
Oh
the
yeah,
instruction
100% Warsaw.
in 7.5e does not create an implied exception to the Act's plain terms. The appellate court found it significant the word person is defined in the Act to include multiple individuals, but that the word people was left undefined. But the commonplace dictionary definition of person is singular, and yet it functions throughout most of the Act as a plural.
G23, if we can get video of the past days and stuff and be able to watch that,
It is a group
um,
made up of individuals as well as all.
I don't know. Maybe we'll do something. I don't know whether it be this weekend or not, but maybe we'll do something watching all
In
of it
ordinary usage, you do
because
so
I want to see that shit.
well, except for that one guy over there. It's a good example of the statute on statutes, which declares that the plural may encompass the singular as well as the singular encompassing the plural. And subsection V is not the only portion of 7.5 that is written in plural. The first sentence of section 7.5 provides that the following shall be exempt from inspection and copying. And it then goes on to list 55 categories of documents and information that are protected from disclosure. And most of them are written in the plural: records, applications, users, and so on. And 7.5B was drafted.
I'll roll 40 hours of trial. Depending on, if I had the days off, I'll roll that shit in one shot.
Because otherwise, if the use of the plural names and people is enough to find an unwritten exception.
But yeah, we definitely need to. We definitely, if we can get video of that G23, we need to watch it because that shit with that ballot measure 114 is insane. Just like all these assault weapons
Under
bans.
the court's logic, I could say, I'm a single user of the public library. I would like my circulation history. I should be able to get it from the library's FOIA officer because I know who I am. I checked out those books. I just forgot which ones they are. I should be able to make a demand of the FOIA officer. Why should I have to go to the circulation desk and show them my library card and maybe my driver's license? Just give it to me right now. You could apply this logic to many subsections in 7.5, which would lead to absurd results.
Yeah, I know, dude. How's the job going, by the way, brother? I meant to ask you that in the chat the other night.
An injunction, Your Honors, it has never been lifted, and it prohibits ISP from releasing FOIA information.
Happened in 86 besides serial numbers being made in the final
This court has explicitly held that injunction.
Dude, there were a few things that happened in 86.
So this injunction needs to be lifted.
I'd have to go back and look at all of it, but there were quite a few things that happened in 86.
And I have nothing further.
Of course, the Hughes Amendment in 86, that was all part of the GCA. Then the Gun Owners Protection Act. And then there was a lot of state stuff that happened in 86. Here's the man right here.
May it please the court, counsel. My name is Thomas Magg. I represent Sandra Hart and Kenneth Burgess in this case.
This dude's fucking sharp. Hey, get back over here. I hit my mouse.
Freedom of Information Act. It's well settled that the public policy of the state of Illinois is that barring an applicable exception, all documents in the government's hands are presumed, strongly presumed, to be disclosable.
Counsel, what about the injunction that your opponent just raised? What do we do with the injunction?
Shut up your ass. I don't care.
With respect to this particular request.
Couple of points on the injunction. One, it was never raised in the original FOIA denial. It was never raised at all in the trial court for Sandra Hart. It was not even initially raised in the trial court for Mr. Burgess, although eventually
Let me look up something real fast.
With that in mind,
hold on.
Every court that has considered it has found that the injunction is inapplicable, and I agree that it is inapplicable. And the reason that it is inapplicable
22.
is what was sought to be enjoined from disclosure is not a person's own records to themselves. What was sought to be enjoined was production of lists of FOID card holders to third parties, specifically newspapers, although it's not limited to newspapers based on the legislative history of
my son's acting like a goober.
and what prompted the lawsuit, and the risk that this information would be published in a public forum.
Supreme Court Illinois decisions.
There is nothing in the applicable injunction that even comes close to saying the state cannot produce records.
Yeah, I saw that, Warsaw. We're gonna look at some of that too.
Or which has
sometime.
already been sent to the plaintiff in this case. They simply lost their copy, and they're seeking.
Can I ask another question? What is your response to the assertion that FOIA was the incorrect vehicle for seeking this information, and that there was another appropriate vehicle that is in place for the parties to get this information without using FOIA?
It's obvious that counsel has never tried to get any documents out of the state.
Okay, I found the summary for the other case.
In some, they don't answer the
So we
telephone
got-
for
we moved
hours
that.
at a time. They don't answer emails for days and or weeks at a time.
Oh,
I
shooting
advise
galleries,
this court
come
to go
on.
to their
But
website and dial the telephone
I'm gonna
number
hang
and
with
see
this.
how many hours it takes to get a person if you even.
matter of fact, let me do something.
Way beyond the record.
That was what my next point was going to be. We're all talking about things that are outside the scope of the record. But if asked, I'm doing my best to answer the court's questions.
So can you respond to the argument that section 2, C5 specifically controls here, that identifies
Shooting
what
gallery.
private information is?
I'm gonna post shooting gallery.
Therefore, that is the kind of information that is not discoverable under the Freedom of Information Act.
Okay.
Hold
What is
on.
private information is not, well, it may well include names, addresses, that kind of thing. But that's not what we're seeking here. Quite frankly, we don't care if the state redacts my own client's names from my own client's records.
Shooting gallery
That's not
New
what
England's
we're trying
going
to
live.
do.
I think he's
What we're
got
trying to get
smash
here is
time
counsel
on
in
tonight.
reference to government action.
So if you
We're
guys
trying to
wanted
get
something that
to
wasn't so
what the
painful to
government's
watch,
stated
yeah, he's got
reason
smash time
was
on.
for revoking, suspending, otherwise
Um,
invalidating my client's FOID
So
card.
shooting gallery's live. So
What happens?
I know a couple of you guys
mechanically
follow
is when a
shooting
FOID
gallery too.
card is revoked, suspended, otherwise invalidated, denied as well, is that a letter is mailed to the applicant, the FOID card holder, whatever the case may be. And there's a line on there required by law that says.
And normally
"This
I'd be
is the
watching
reason
shooting
that we are
gallery, but
suspending, revoking,
I'm
denying."
gonna stick with what I got going on because
At the end of the day,
these
that's
cases
what
are
we're
interesting to
interested in.
me.
We don't, Sandra Hart, Kenneth Birch doesn't need to be told what their own name and address is. They do want to be told what the stated reason they're not being allowed to have a FOID card and thus exercise their Second Amendment rights is, so that they can determine whether or not.
Yeah, that's from what I understand. It's the biggest thing about this case. This little girl like sitting back there, man spreading in the brown dress. The way I paused it, it looks like it is. Oh, she might be cute. Might not be a bad thing. She might be airing that cookie out too. But yeah, part of this is, man, these people, the state police would deny you because they're the ones running the thing. So state police would deny you for your FOID card, and then you want to know why, and they're not giving you an answer. They're just like, we don't have to answer that. That's why people were making FOIA requests from them. To Alpha, I don't know. I don't think so. Because I think they have to have a permanent address really to be able to do any of it. And it's one of the reasons this FOID card crap, another reason, now that you bring that up, is so insane.
They can challenge that or not. And if they choose to challenge it, there are two mutually inconsistent mechanisms to do so, depending on the reason that's articulated by the state.
I wish
One
I could
is
zoom
the
in and see old girl over there.
Which
No, it doesn't do anything to stop
for certain
crime.
categories of denial.
Chicago is in Illinois.
The other is a circuit court action for other categories of denial, suspension, revocations. And never the twain shall meet. You can't, what is appropriate for.
Yeah, that's pretty much it, Alpha.
Is usually, almost always, not appropriate for a circuit court review or vice versa. If we were to file in the circuit court.
And someone having a firearm, just them having a firearm, should never be a crime. Should never be an issue. It's what you do with it. Chicago said. Yeah, we might look at that one. Warsaw. But yeah. And it's amazing to me, like New York, couple other states. Oh, you get caught with a gun. Oh man, you're going to jail. I mean, there's no lie about it. You are going to jail when they catch you with that gun if you don't have the state's permission. And then you're going to have to spend money to defend yourself. There's no way just having a tool should be a crime. It's what pisses me off with police. Because the police are the ones who are going to get you. They're the ones who are going to arrest you. They're the ones who are going to slap cuffs on you. They're the ones going to bring you to their county, city jail just for having a gun. Doesn't matter. In some cases, we've seen people were passing through a place like New York. They had the gun locked up in a case in the back of the truck, no ammo in it. They get to go to jail because they had a gun that, it's cops who do that, cops who enforce rules like that. Those cops should go to in prison. I'm trying to be as nice as I can because my son's sitting right here. But those cops are the ones that should go to prison. And I've said it before, if you are going to enforce laws in the United States, and our laws are supposed to be based on this Constitution, if you're going to enforce laws, you should have to know the Constitution and what you're supposed to enforce as far as a law. You should be able to say, no, I'm not enforcing that. And let me tell you something. If you are a cop and you do enforce a lot of these gun laws, you deserve to be in prison. Yeah, New York's insane, which a lot in other states are getting just as crazy. New York's not an outlier anymore, whether it's the Sullivan Law or anything else. But there was, I'd have to find it. John Stossel did a show as far as gun laws go, and this lady, they were flying home from somewhere. Anyway, they got stuck in New York. They had to get a hotel room. So, of course, in her baggage, she has her self-defense gun. She's got her EDC. Anyway, she gets stopped with it. And Susie Homemaker, who's probably only a threat to, I don't know, cupcakes, gets thrown in jail and has to spend thousands of dollars to defend herself against these charges in New York.
What's appropriate for an administrative review, it would be dismissed for lack of subject matter jurisdiction. If we were to file in the administrative review process, what's appropriate for a circuit court action, in frankly 2 or 3 years, if we're lucky, we'd get a denial that said you filed this in the wrong place.
Yep.
And it would also.
So then what do we do with 7.5B?
My wife's sending me messages saying she's about to lose her shit.
From inspection and copy.
Someone might die tonight.
Names and information of the people who have applied.
Who knows? Could be me.
A card, or applied for and received.
Don't slam the door, goober.
Following shall be exempt from inspection and copy under.
You don't have to smash the door shut.
You've generally read the statutory provision correctly. Again, we're not interested in our own names. We're not interested in our own clients' addresses, social security numbers. We already know all
Don't
that.
slam the door.
What we want is the
Have
why
it plugged in. Leave it plugged in.
the FOID card was denied, revoked.
Kid
And
it.
notably, it's something that the state either has or is otherwise supposed to have already sent
Like
to
my
you.
wife sends me a
Or
message
which
says
is
she's
already
fixing to lose her
generated
shit.
by the
I ask her
requester
why, and she
themselves.
just says people in all caps.
Again, when you're looking at the plain language of the statute,
It says what's exempt from copy. A number of things. I give you an opportunity, but the last line is, and law enforcement agency objections.
Yeah, no kidding, Sam.
Concealed carry act. That's one of the things that's listed in the statute that is exempt from inspection and copy.
and we're not asking for that.
But it also says information. It says the names and information of people who have applied for or received. So you said you don't care about their names or their addresses, but it's the information about their denial, revocation, suspension that you're seeking.
Yes.
Information is specifically listed as
The legislative history in this case indicates not that the legislature was concerned with Illinois citizens getting their own information.
Let me start here. Let's talk about plain language first.
Okay.
Okay, let's talk about what this language says specifically. The following shall.
Okay, you want to talk about plain language there, but you don't want to talk about the plain language of the Second Amendment. That plain language doesn't matter. Your plain language matters when it's in defense of the state.
Shall be exempt from inspection.
What are you doing, boy? You're give me your tablet.
Information. What?
You gotta leave it
what
plugged
is
in for a little bit.
Saying that you are requesting that does not fall into.
You can hang out in Daddy's office. You just gotta
plain
leave.
language as to.
Don't you
these
grunt at me,
documents
boy.
Cannot be discovered under
You
FOIA.
ain't got enough pad on that butt no more.
We're not looking for our own clients' names. We're not looking for our own clients' addresses, their FOID card number, their social security number. We're not looking for our own client's date of birth. We know all of that.
No, leave it
What
plugged
we're
in
looking
for a little
for
bit.
is what the state did, what its articulated reason was.
Jason, what's up, my brother?
for
Much
denying,
love.
Revoking, suspending our clients'
How's Shauna
FOIA
doing?
cards, so that we can determine whether or not it's factually accurate.
And why does that information that you're asking for not fall within this specific statute? That's that question we're asking over and again. Specifically, the legislature said these documents are not.
Okay, first of all, the FOID card's absolutely unconstitutional from the ground up. Second of all, while the FOID card is there, if you deny me or you suspend me or you revoke me, the state should, one, that should be a court proceeding. Two, they should have to give me the information on why they denied me, delayed me, suspended me, revoked me. The state should have to give that information up. Period. It shouldn't even have to be asked for.
Available for inspection and copying under FOIA. Explain to us how your request does not include any of those long list of documents.
One, as noted by the appellate court.
Hey, can't turn down cheeseburgers, brother. Just saying.
The person can, there's an exception for their own information.
Yeah, I forget Jason's up Pacific Northwest too.
Two, the information we're seeking is not about the person. It's why the state did what it did. We're not interested in, like I said, our clients receiving identifying information on themselves.
But counsel, it says names and information of people. It doesn't say names and information about people or identifying people. And that's pretty broad, isn't it?
It
Two
can
Alpha
be
Life
interpreted
been damn
broadly,
easy,
but I
Jason.
don't think that's the
They already been chowing on
that
dinner.
that would result with an absurd
Probably
result.
some good stuff.
And of course, statutes are.
I think we're gonna roll with some sketty here a little bit.
Intend an absurd result.
Yeah.
It would be absurd.
We're trying to figure out what the legislature wanted, right? That's our goal here.
Yes.
And our first step is plain language. I think that's what we're all talking about.
Now, our first step should be that the state has no power to regulate arms in the first place, and the FOID card should never have been a thing, ever, 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 never, ever.
We're reading this section. There are really two sections, but this section specifically, we're talking about 7.5. What
Yeah,
these
I'm
words mean.
done.
That's our goal here. Okay. And we're debating what these words mean, where it's specifically, there are certain documents that cannot be inspected and copied under FOIA. And another piece of it, of the same statutes.
There should not be a single piece, sentence, period of information that the government has on me that I shouldn't be able to request and get within an hour, basically. It shouldn't even be a question.
Has an exception that
But
can
hold on, I
be,
can't make that
where
bigger.
information can be reviewed.
That shows me to
And
pay
that's under
attention.
the databases under the Firearms Concealed Carry Act. Records of the Concealed Carry Act Licensing Review
We
Board.
get a better look at old girl
Firearm
in that
Concealed Carry Act.
kind of
And law
brown,
enforcement agency
khaki tan
inspections under
dress.
the Firearm Concealed Carry Act. So you say that that doesn't work very well, but that's not what we're talking about. We're saying this is what the language says.
Well,
That
if you want,
this is not, these documents are not subject to FOIA, can't be inspected or copied, but there are other avenues where people can get information.
well, if you want to get ultra technical, the unless otherwise authorized by the Firearm Concealed Carry Act. If you
Ah,
go
I
to
just
the
got a
Firearm
legs crossed
Concealed
now.
Carry Act, it expressly authorizes the release of denials and revocations of concealed carry licenses, which are.
Oh shit! Now I'm looking at a girl in the red dress
printed on
back there.
FOID cards.
She looks a little
So
psycho.
if you want to get ultra technical, that's an authorization under the Firearm Concealed Carry Act.
Automatically
don't
mean I
we
think
get
she's
that
hot.
far because we're not seeking information of people. We're seeking information of why the state acted for the persons who they acted against, which was actually either already been sent and lost, or has, in this case, they were sent, but in other cases.
Council, the legislative, the language of the statute, I think is clear. You don't like what it says, but it's clear. Isn't your argument, or shouldn't your argument be that the legislature should amend the statute and change the language if they intended it to apply in the way that you're arguing? Because the language of the statute is clear. I don't think we can look at legislative history when.
Hey, the language of the Second Amendment's really
I
clear.
mean, you don't like what it says, but it seems pretty clear. So isn't your quarrel with the legislature in terms of maybe amending the statute to say what you think it's
Oh, my
saying?
quarrels with all
I
of you.
agree the statute is not the model of clarity.
Well, that's the opposite of what I said. I think it's pretty clear. It may not be what you like it to say, but it's pretty clear.
Thank you.
Legislative history does not support the interpretation that a person cannot.
Yeah, you know you can eat the whole candy,
When the
right?
statute is clear, do we reach the legislative history?
In determining the plain meaning of the statute, there are things the court can consider. One of which is the problem sought to be addressed by the legislature. The problem sought to be addressed by the legislature was not persons getting their own information. It was third parties trying to get their information. And the reason for the law was not to prevent not to get persons from getting their own information.
Oh, girl,
The
just
reason
chewing on
for
that
the
nail
law
back there.
was third parties from disclosure.
Gonna bite that damn thing off.
You know, I agree with that. What about the argument that
I
one
thought
of
you
the
laughing at me
reasons
for a minute.
for making sure that only people who are the real person seeking their information are the ones that are getting it. Only the requesters. If you're requesting your own information and you're really the requester, you have another vehicle for seeking that information other than FOIA, and FOIA is
You think,
to
Warsaw?
the general public or to other seekers and not to individuals who are seeking their own information. What about that argument?
The only other avenue I can come up with that's not questionable at best we could file a discovery action in the circuit court, naming the Illinois State Police and seek it that way. But I think that would be a waste of resources when all you have to do is send a request under the Freedom of Information Act. Right now, if you go to the state police website, there's a form on the state police website that references 7.5V that for you to verify your identity to send it along with it. It didn't exist when these cases were filed, but it's there now. So if they want you
would
to
it be a
verify
case
their
where
identity,
the
all
state's
they
trying to
have
cover
and
their
you haven't
butt?
done it. All they have to do is send it back with a copy of that form that's on their own website and said, please fill this out and verify your identification.
Council, I have a question regarding section 1C of the act where it says that personal information, the disclosure of which constitutes
Dude,
unwarranted.
fire, we are going to deal with a lot of Biden
Unless
appointed
disclosure
judges
is
here
consented to
in
in
the next
writing by the
while.
individual subjects of the information.
Biden's put over 150
Would that
judges
mean
on the
that,
circuit and
right,
district
and
courts.
your clients
All,
filing
of
their
course,
FOIA
federal
request,
judges, but
not only that they can obtain whatever information is in their file, but that anyone else could as well?
I believe that if the client consented appropriately, yes, you can authorize persons to obtain your information, just like you can authorize third persons to obtain your federal tax records if you fill out the right form. I mean, you can certainly waive attorney-client privilege, among others.
So is that what you're saying that your clients did under 1C was to waive?
no, it's not going to be a Clarence Thomas.
No, they simply requested their own information. They didn't authorize it to be released to newspapers or generally to random people off the street.
Remember, these are state judges, so all of these were.
I would simply like to close in the.
I guess I don't know whether these judges, because this is an Oregon
what we're
State
seeking
Court
is
or
our
State
own
Supreme Court.
information. We don't want.
I don't know
anybody
whether these
else's
judges are
information.
voted in or whether they're
We want the
appointed by the
information that shows
legislature.
what the government did. There is no other system under the law to get documents short of a discovery action or a subpoena. You can't send a subpoena without a court case on file.
And not the database that council referred to? You're saying you cannot get that information from the database?
Google.
But
Fire
because-
What tablet in?
Bureau.
It's in their database, I'm quite
Oh, yeah.
certain.
And you could get, I mean, that's what it's set up to do. So you could get that information.
The record in this case does not indicate that. I can represent that probably in the last 6 to 12 months. For some people, that's possible, but not for
That may
everybody.
be a different argument. But
That'd be a different
the
argument.
statute creates this other path for someone to get their own information.
I'm
correct?
not aware of any citation to that authority provided by, in the briefing. That simply seems to be argument of counsel.
And we know council's
Sure,
arguing for the state and they're
A
full of
response
crap. So
discovery action or a subpoena from some case on file. I'd ask that the court affirm both the appellate court and the trial courts. Thank you.
Thank you very much.
so that was that one.
Rebuttal from the-
Now we get the rebuttal. And remember, she's the lawyer for the
Your Honor,
state.
the presence of private documents in the government's possession, in the government's files, does not convert them into public documents.
Counsel,
Yes.
sorry to interrupt, but
No.
I'd really like you to start with this notion that the Firearm Services Bureau, that is not a mechanism by which you can obtain this information. That's what your opposing counsel said.
But in fact it is. Every agency has a way of getting your private information if you need it. Secretary of State makes you pay money to get your driver's history, but it's $8. Firearms Services
Press call.
they will give you your documents if you provide them with proof of identity. This case went out very early on the pleadings, so there wasn't the opportunity to make an evidentiary record that we otherwise would have made. But people can get their documents that way. But what's interesting is what these plaintiffs were seeking were paper copies of the applications that they filled out. And paper copies have not been used in years, not since that portal was created. Now you don't fill out paper. You apply online and you go from one screen to another. And you don't have a form that you fill out. It's one screen to another. And so there isn't a paper copy to be had. So one of the things that tells us is that whatever information it was that made these plaintiffs either ineligible for a FOID card, that's years old. It's stale. It's too late to appeal that. They're certainly entitled to that information for their own personal records, but if what they really want is to get a FOID card to exercise their Second Amendment rights, then it would be much easier and probably less expensive than court action to pay the $10. Not to suggest that that's de minimis, but pay $10 and reapply.
Well, counsel, opposing counsel is saying they want to know the basis for the denial.
Exactly.
So you're saying that there's no paper that exists that would have that on it, but that they could get that information somewhere else.
I apologize, Your Honor. I really wasn't clear. I meant that there isn't a paper, well, nowadays there isn't a paper application. These plaintiffs, I do believe, filled out a paper application because they're asking for paper copies. You can't get paper copies now, but you could get a copy of what you filed pre-2015. And also their denial letters would be on file on paper. The problem is under FOIA, some of that, if you release those documents under FOIA, you're going to have to redact all that private information. Often, well, if someone was denied a FOID card because they had a certain kind of criminal conviction, okay, that's a matter of public record, but not all denials are based on that. Some of them could be on someone's juvenile history. They could be on somebody's mental health history. There could be a reason that is protected. So that's going to be redacted too. And in the end, that isn't going to help these plaintiffs know why they were denied or revoked. And people can pick up.
Ms. Nguyen,
Yes.
if all of the information that was personal was redacted and just the conclusion of why the denial was made, so you wouldn't be able to match that to anyone. It would just be a conclusion, which is even different than an objection, but it's what the conclusion was and why the denial was made. And that's all they're seeking. Why is that prohibited?
What I'm saying, Your Honor, is the reason that they were denied may or may not have to be redacted. So it's possible if they were to get a copy of their denial letter, they might be able to see the reason if it was a matter of public record. But if it was one of these other matters, juvenile history, history of addiction to narcotics, recent mental health hospitalization, that kind of information is protected, and that would be redacted. And so in the end, a letter like that, all it would tell these people is what they already know, that they were denied or revoked, and it wouldn't tell them why. Unless there are further questions on that point, I would just like to point out that 7.1c of FOIA is for public documents that have potentially embarrassing information in them, like the names of witnesses in an investigation. It's a complete, that you can consent to if you want, but that's a completely separate matter from 7.1b, which makes that information off limits. Unless the court has further, I want to jump the gun. Unless the court has further questions, I would urge that for all the reasons stated today and those in our brief, I would ask that the appellate court's decision be reversed.
Thank you very much, both counsels, for your spirited argument. This case, agenda number 14, number 128275, Sandra Hart et al. Versus the Illinois State Police will be taken under advisement.
The next case on the call of the docket is agenda number 5, case number 127201, People of the State of Illinois versus Vivian Claudine Brown. Mr. Fisher.
Good morning, Your Honors. Counselor, may it please the court, Assistant Attorney General Garson Fisher for the people. Your Honors, before I address the constitutionality of the FOID Card Act as applied to this defendant, I think it's incumbent to address the procedural matters that the court asked the parties to grapple with in the supplemental briefing. The parties are in agreement that the trial court did not exceed the mandate. In Brown 1, this court directed the trial court to reinstate the order dismissing the indictment, but relying solely on the purported statutory interpretation issue. And that is exactly what the trial court did on remand. Now, typically, that would, of course, end the matter because the trial court can't reconsider a merits determination by this court. But in Brown 1, the court was explicit that it was not making a merits determination. on the statutory interpretation question, and in fact invited continued review of that question. So the trial court was within its authority to reconsider that ruling. Now, the second question, of course, is whether the defendant could move to reconsider that ruling. And it is certainly unusual for a defendant to move to reconsider an order dismissing the indictment. But in this case, the defendant had been put in the position of effectively adopting an argument that she did not mean to adopt. And based on defendant's briefing in the trial court and before this court, that defendant didn't even think was a colorable position. So defendant informed the court that rather than be put in the position of having the delay of an appeal in her criminal proceedings, in which she would not have been able to, in good conscience, defend the trial court's order, that she felt it was in her own interest, in the interest of finality of her criminal proceedings, to ask the trial court to reconsider that order and reinstate the indictment and move proceedings forward.
Mr. Fisher, though, but is it ethical for a criminal defense attorney to move to vacate an order?
Yeah, I was on the phone.
Relief?
I think
so. This again. Let me show this real fast since we're in this case. This is the opinion summary for this case. And the courts, I believe, actually shot this one down. So this is 2017. Brown was charged with violating Section 2A1 of the Firearms Owner Identification Card Act. And I'll have to look up the text for that, which requires a person who possesses a firearm in Illinois to have a Firearms Owner Identification Card or the FOID card issued by the state police, yada, yada. Brown challenged the action as unconstitutional as applied under the Second Amendment, because remember, since the 14th Amendment or whatever it is, the Second Amendment covers all states, which even under the state constitution, the FOID card is illegal. Finding that the legislature did not intend for the FOID card act to apply in a person's home, because such an interpretation would lead to unworkable results. Supreme Court stated the court's opinion ruling 2-1A is unconstitutional as applied. So it was just in this case, like having a gun in the home, the Supreme Court of Illinois said it was unconstitutional. So they remanded the case back to the district court. Looks like they vacated it. But anyway, this was someone who had the gun in their house, and I have to look up the whole case because it was an interaction with law enforcement. They found out she had a gun in her home, and of course, and I believe it was her, they arrest her. Which, to me, those officers themselves should have gone to prison for that shit. But anyway, so now we get to this argument about the FOID card and whether it applied in the home. That was the major part of this challenge. Yeah, it was a .22 rifle. Yep. And that was the original lawyer bouncing from the case. Just flip one more thing. See these dumb motherfuckers talking about up here. It's legally required de minimis steps. It's only a couple of small steps to be able to practice your right. You just have to go through all of these steps and get the permission from the government. De minimis. Dude deserves to be punched in the face just for saying that. Apparently, my wife is having some issues. Crow, what's up? Chicago Mike, my brother, what's happening? We're talking about Illinois, brother Mike. Illinois and FOID cards and FOIA requests. I want to see you discuss the historical pedigree of a FOID card. I want to see that. Do you not hear anything on the? Oh, hold on. Let me back it up because if you guys didn't hear that, all right. Let's see. Okay, I swapped that around. Make sure you guys can hear this again.
Question, and in fact, invited continued review of that question. So the trial court was within its authority to reconsider that ruling. Now, the second question, of course, is whether the defendant could move to reconsider that ruling. And it
Can
is
you guys
certainly
hear it now,
unusual for
5 by
defendants
5 and
to move
everything?
to reconsider an order dismissing the indictment. But in this case, the defendant had been put in the position of effectively adopting an argument that she did not mean to adopt, and based on defendant's briefing in the trial court and before this court, that defendant didn't even think was a colorable position. So defendant informed the court that rather than be put in the position of having the delay of an appeal in her.
Yeah, I remember this lady. I'd have to look up the whole case. Anyway, she's got a 22 rifle of all things. And I think the police were called for something. Anyway, oh my God, she's got a rifle. Freaking 22. And all of a sudden they want to put this chick in jail, put her in prison. Not just jail. They want to put her in prison. They want to tear her life to pieces, put her in prison, give her felonies for merely having the object. Anybody who enforces this, anybody who writes laws like this, ought to be in prison. Judges that uphold this shit should be in prison for as long as people have been sentenced for that. So if you had 5 people that serve 10 years apiece for these laws, these judges that uphold this ought to be in prison for 50 fucking years. I don't give a shit whether they die. Their corpse should stay there.
Criminal proceedings in which she would not have been able to, in good conscience, defend.
Mike, how them roads out there, brother? You staying safe?
That she felt it was in her own interest, in the interest of finality of her criminal proceedings, to ask the trial court to reconsider that order and reinstate the indictment and move proceedings forward.
Is it ethical for a criminal defense attorney to move to vacate an order that grants his client complete relief?
I think so. It was in this very unusual set of circumstances, Your Honor, because counsel had been put in the position of having his the indictment against his defendant dismissed on grounds that he could not have, in good conscience, have defended on appeal. Because the parties all agree, and I don't think anyone has ever, as a merits determination, concluded that there was any basis for the so-called statutory interpretation of the FOID Card Act that it doesn't apply in the home. There's certainly no language in the FOID Card Act. There's nothing to suggest that the FOID Card Act was not intended to apply in the home. So here, his client's interests in getting to the end of the finding finality in the criminal proceedings against were actually
saying it was just the fact that
moving
you
the
had
ball forward in the trial
you
court,
had that. We
rather
didn't
than
give you
facing the
permission to have
delay
that.
of an appeal
We're
where
gonna throw
he
you
wouldn't
in
have even been able to defend the order dismissing the indictment because there was no good faith legal basis for defending that order. Now, I will also note that it does not harm the state's interest in defending the constitutionality of this statute as applied to defendant.
The state's interest shouldn't even come into fucking play. Especially this is after Bruin, is it not? The state's interest shouldn't even come into play in this. And fuck a piece of shit who argues for the state for this stuff.
If this court were to dismiss the trial court's order on these grounds, that would, in some ways,
I'm thinking Warsaw. I think
this
case happened after Bruin.
The state is nevertheless content to allow
maybe this was just a little
resolve
before.
The constitutionality of the FOID Card Act as applied to this defendant because it is plainly constitutional. Defendant doesn't challenge the constitutionality of the substantive restrictions in the FOID Card Act against inherently high-risk groups like felons.
Yeah, that was the protection for legal commerce and arms, PLACA.
And as the Seventh Circuit recognized in Barron and other courts have recognized across the country, if the state can constitutionally impose such substantive restrictions on possession of firearms by these groups, then it follows that it can use a licensing scheme to determine who falls into these high-risk categories.
Hold on. So he's saying this, the state can use this to figure out who falls into these high risk categories. So you're saying anybody who wants a gun falls into a high risk category. That's what I'm hearing from this fucker. Z, what's up, my brother?
Except, counsel, in this case, the licensing scheme applies to even law-abiding citizens.
It imposes a de minimis burden
De
on
minimis, my
law-abiding
ass.
citizens to allow the state to determine whether they are in fact a law-abiding citizen who has the absolute right to possess a firearm in their home for self-defense or falls into one of these high-risk categories. The FOID Card Act is the mechanism by which the state answers that question. And without taking the easy, inexpensive steps necessary to give the state that opportunity, the state can't answer that question of whether someone does have that absolute right to possess a firearm at home for self-defense, or in fact is a felon or mentally ill and thus doesn't. So had defendant never applied for a FOID card. Had she applied for a FOID card, and if, as she insists, she is eligible for one.
Hold on. If she insists she's eligible for one, you guys have already taken her to court, put her through the ringer. You guys know good and damn well she was no prohibited possessor when you started this. Is it just me, or is old girl on his left, my right got a "I'll kill you" look on her face? Because that definitely looks like an "I'll kill you" look. Which, if she's arguing for the plaintiff, I can see why.
She would have received one. And then she absolutely could have kept a loaded, operable, readily accessible firearm at home for self-defense. She didn't get in trouble because she kept a firearm at home for self-defense. She got in trouble because she didn't take the...
Warsaw, we all know, whether it was the FOIA cards or just CCWs, any of that, we all know that has not stopped a single crime. It has, however, created a bunch of unarmed victims, but it hasn't stopped a single criminal. Z, you gonna hang a night vision periscope out of your car or your truck?
Legally required de minimis steps necessary to give the state the chance to answer that question.
Yeah, but the issue is casting this broad net over the entire population of the state of Illinois when we're looking at an extremely small subset of people, felons and people who have been declared to be
Thank you,
mentally ill.
Judge.
So we cast this broad net. So the issue is the means justifying the ends, and are the means reasonable? I mean, I'm sure we'll get to the issue of scrutiny and whether any scrutiny applies or which scrutiny applies. But just as a preliminary
$4.99.
matter,
Hell, that ain't bad.
I think just piggybacking on what Justice Overstreet said, this is a very broad net to catch a very tiny subset.
Well, that's what
Several
all of
answers,
these
Your Honor.
gun
Many
laws
of them
are.
get to those issues that you suggested.
That's what the 1934 NFA is. It's a very broad net to catch a very small subset of people, the mobsters. And in effect, it has put more innocent people in prison than it has gangsters. And they admitted it was going to do that in the hearings. And I'll guarantee you go back and listen to hearings for the FOID card, the same things were said.
In your question, but as an initial matter,
if you're arguing for the state in these
people very
circumstances,
differently,
you deserve to
status.
go to
It is a prohibition on possession of a firearm at home for self-defense. for people who fall into those limited categories. But for people who don't, for people who can lawfully possess a firearm at home for self-defense, it's only a minimal burden on them. And that was, for example, the basis that.
Now, wait a second. I will guarantee you, part of the same people that will argue that having an ID to vote is too much of a burden on people.
The DC Circuit applied in Heller 3 specifically to uphold at the first step of this.
You look like you straight out ready for
the district's requirement that all long guns be registered. We can discuss the historical pedigree of these kinds of regulations, but even in the absence of an historical pedigree, the DC Circuit said that the requirement that long guns be registered
fully baked cream pies or get my
was
goddamn
constitutional at the
nerves.
first step of the analysis because it applied only a de minimis obligation.
Y'all pray for my wife. Hell, pray for me. She might murder my ass
lawfully
tonight.
possess firearms, and the same is true here. The FOID Card Act doesn't restrict how a licensed gun owner keeps a gun at home for self-defense. It just requires that
Came off an M1A1. Hell,
present themselves to the state so the state can answer the very quick, inexpensive, easy question: is this person?
But I mean, there's a threshold
lawful
issue
gun
here too. I mean, the Second Amendment allows people the right to keep and bear arms, and that right shall not be infringed. And that right shall not be infringed by the government. And what we have here is the government telling the citizen, every citizen of the state of Illinois, you really don't have Second Amendment rights until we tell you you have them. And you're telling me that's not an infringement?
I disagree with that characterization of the FOID card. I mean, of the FOID Card Act and its relation to the Second Amendment. First, we do know from the U.S. Supreme Court, from this court's jurisprudence, and while not binding, instructive opinions from circuit courts across the country, that there are many ways in which the Second Amendment right can be constitutionally regulated. So yes, the Second Amendment provides the right, the core of the right, as the Supreme Court defined it, to keep a gun at home for self-defense. But that right is not absolute in the sense that it cannot be regulated. We know it can be regulated. And I think that the Seventh Circuit's analysis in Barron, which admittedly applied to the concealed carry permit, but its analysis applies equally to the FOID Card Act. And I think it's clear, looking at that analysis, that the Seventh Circuit would have reached the exact same outcome had it been presented with the question now before this court. We know that among those constitutional regulations are restrictions on possession by certain high-risk groups of people. And if the state uses a licensing scheme as its mechanism to quickly, again, I mean, there's a 30-day limit on how long the state police can look at it. And our understanding is that at this point, there is not a backlog at the state police. They are processing these.
I'm gonna let Fat Boy run it. Well, like I got in a room talk about Fat Boys. So I'm gonna let Fat Boy run his mouth for a second.
Categories. If
And,
the state can constitutionally impose these
throw something in the
substantive
skillet real quick.
regulations,
I was trying to work
and
out.
that's not contested right now, then it can constitutionally use a licensing scheme as an easy, straightforward manner of implementing those regulations.
But counsel, I understand it, Illinois and maybe one other state, Massachusetts, are the only states that have a FOID Card Act. Aren't there less restrictive alternatives to meet the state's concerns?
There are alternative ways that one could approach this problem. I think it is noteworthy that
Back in a minute.
the amicus brief from the city of Chicago and Cook County, which represents 40% of the population of the state, indicates that this is actually one of the more useful tools in their belt for accomplishing this goal. Our position is that this is constitutional at the first stage, at the first step of the analysis, because we know that the substantive regulations fall outside the scope of protected conduct under the Second Amendment, that the licensing scheme, which is this simple, minimally burdensome approach for applying that, is similarly constitutional at the first step. But even if we move to a means ends analysis, it's intermediate scrutiny that applies. So the question is not, is this the absolute least burdensome possible way of achieving this end? It's whether there's a substantial relationship between the means and the end. The end, keeping guns out of the hands of these high-risk groups, is not disputed. The question is the fit between the two. Our position is that simple intermediate scrutiny applies because this is a minimal burden on law-abiding citizens' ability to keep a gun at home for self-defense. It's a regulation, not a restriction, so to speak. And on its face, the FOID Card Act bears a substantial relationship to this legitimate government end because it answers the specific question that the state is authorized by the Constitution to ask. Do you fit into one of these categories? And that's all that the act is doing, is giving the state the opportunity to ask that question. There is certainly significant empirical data provided in the state's brief, and I think the Giffords Law Center amicus brief, demonstrating that this is also an effective mechanism for achieving that end. But on its face, there is a substantial relationship between requiring someone to take these easy, inexpensive steps of applying for a license to answer this one question, and the goal of keeping guns out of the hands of people who fall into these inherently risky groups. And again, that's what the Seventh Circuit recognized in Barron, that this is the way the state accomplishes these substantive regulations that the courts have repeatedly said are constitutional.
Counsel, if we agree with you, does it mean that at least every adult that lives in a home with a gun has to have a FOID card?
Not necessarily, Your Honor. I mean, the question of whether one possesses a gun, whether one constructively possesses a gun, is answered by a number of factors that the court has applied in constructive possession cases in all different kinds of settings, including homes and vehicles and so on. There is no contention that this defendant, this is an as-applied challenge, that this defendant was merely related to someone else who was a licensed gun owner who possessed this firearm and sort of got swept up through some sort of constructive possession, overreach. So the court doesn't have to answer that question in this context. But I would also add, Your Honor, that to the extent that there is a firearm in a home and multiple adults who live in that home have control over the location where that firearm is kept and access to the firearm, that the state has a comparable interest in ensuring that each of those adults does not fall into one of these high-risk categories. And so even to the extent that every adult in a home who has constructive possession over a firearm in the home is required to have a FOID card, that similarly would also be constitutional, most easily stated at the first step of the analysis, but also even if means ends analysis were to be applied.
Why wouldn't we jump to the second step? I mean, we did in Cherez. I understand the law was different, but I mean, in Cherez, this court said we should assume some level of scrutiny when there is a restriction on firearms. And here you've said it's a burden. You're arguing it's a de minimis burden, but it's a burden nonetheless. So there is a small level of infringement on an enumerated constitutional right. Why wouldn't we just jump to the second step?
Well, Your Honor, I think for a couple of reasons. First off, this kind of regulation has an historical pedigree that suggests that it was outside the scope of protected conduct, that it was understood by the framers at the time of drafting. There were statutes that existed at the time of drafting that allowed the states to keep track of who had guns and inspect them to the extent to determine whether they fell into a category that was deemed unfit for possession of firearms. So there is an historical pedigree, and even regulations of much more recent pedigree, such as restrictions on possession of machine guns, have been held to be longstanding for purposes of falling outside the scope of the Second Amendment. And in fact, the kinds of regulations, like the substantive regulations here, restrictions on possession by felons, restrictions on possession by the mentally ill, which the Supreme Court explicitly recognizes longstanding, are also of 20th century vintage. So there is a historical pedigree that creates a presumption that this this kind of regulation falls outside the scope of the Second Amendment and allows it to be upheld at the first step.
But again, we said in Chairs, we recognize the presumptively lawful regulations. We recognize that, but we still jump to the second.
I think the problem in Chairs is that the regulation didn't fall into any of those presumptively constitutional categories. And the burden in Chairs was, of course, again, the DC Circuit, I think, in a very instructive way, said even in the absence of that kind of historical pedigree, you could, in the context of de minimis burdens, recognize that they fall outside the scope of the Second Amendment. Neither of those rationales apply to Chairs. Chairs was a complete restriction on carriage in much of the state for everyone, or essentially everyone. And there may have been exceptions for certain law enforcement officials and so on, but effectively banned everyone from possessing weapons in a large chunk of the state. That's a very different kind of regulation. And it was appropriate, therefore, under those circumstances, to step past the first step fairly quickly and turn to means ends analysis. Now, again, the state's position is that even under intermediate scrutiny, this statute, unlike that statute, survives means ends analysis, but Chairs was a very different kind of restriction as opposed to a de minimis regulation that has a historical pedigree and that doesn't apply any more than a minimal burden on law-abiding citizens, on the vast majority of people keeping a gun at home for self-defense. As your honors recognized in one of your questions earlier, for most people who don't fall into these categories, they're not going to be restricted from keeping a gun at home for self-defense. They give the state the opportunity to look and say, yes, you fall into this big category of people who have this right to keep a firearm at home for self-defense. Here's your license. Go defend yourself in your home as you see fit. So this is a very different kind of regulation than the statute that this court was addressing in Chairs. And that's why the first step of the analysis is applicable here, whereas it wasn't in Chairs.
Mr. Fisher, I just have one last question. When is the Supreme Court's order not followed, the mandate? I'm kind of concerned about you saying that once this court remanded with explicit instructions to enter the modified order, the court did that, but then entertained the reinstatement. How could the circuit court do that? Disregard the order of the Supreme Court?
Because of the unusual circumstances here, Your Honor, where this court explicitly said this is not a merits determination. In the vast majority of cases,
the court said what? This is not?
That it was not a merits determination, and in fact explicitly invited further substantive consideration of the question. In the vast majority of cases, if this court were to remand to a circuit court with explicit orders to reintroduce a judgment on a specific substantive basis, the court could, of course, not reconsider that. Trial courts have no authority to reconsider the merits determinations of this court. But Brown 1 was explicit that it wasn't making a merits determination, and that further consideration by at least the appellate court was authorized. But again, if this court were to vacate on that basis, it would advance the state's interest in preserving the constitutionality of the statute.
But what we said was that we direct that the order entered by the circuit court on February 14, 2018 be vacated. We further direct the October 16, 2018 judgment order dismissing defendants' information be vacated and then modified to exclude the ruling of that section is unconstitutional. See, the trial court could have used, not constitutional issues in their order, but the unconstitutional issues is what I'm talking about.
So, Your Honor, if I can answer your question.
Yeah,
I guess I hadn't considered the idea that the second order issued in response to the motion to reconsider exceeded the mandate specifically because it brought back, not the order reconsidering, the subsequent order after the defendant filed a new motion to dismiss the indictment exceeded the mandate. if the court were to conclude that that was the case and dismiss on those grounds, then it would once again reinstate, I guess, the trial court's order dismissing the indictment on other grounds.
Have you had any?
My understanding, my way of looking at it was that the mandate required the issuance of the order dismissing on the non-constitutional grounds that had been addressed in Brown 1. And the court did that. And then because this court had invited reconsideration of the specific statutory basis.
The court did that? I don't see.
Yes, in
anything.
Brown 1, the court explicitly said, we are not making a merits determination
And
about.
it just said there's non-constitutional ways of dismissing it.
Well, and
Is that an invitation?
Well, and the court also specifically said that that issue could be addressed, further addressed at the very least by the appellate courts on review of the order dismissing. So I consider that to be the specific invitation, not the fact that there were unconstitutional grounds. Once that order was issued, so long as defendant had the authority to ask the court to reconsider it, and the court did reconsider it, the proceedings were it was new proceedings, so to speak. Like there was a new motion to dismiss the indictment. So I hadn't really thought of the order in response to the motion to dismiss the indictment as a continuation of the court's response to the mandate. It was, a new half had started, so to speak, after the order that had been mandated by this court was reconsidered. But again, it's not adverse to the state's interest in preserving the constitutionality of the statute for the court to vacate the trial court's judgment on these grounds. We're just equally comfortable with the court addressing the constitutionality of the FOID Card Act because we believe it is plainly constitutional as applied to this defendant.
Thank you.
Unless the court has any further questions, we ask that you vacate the trial court's judgment. Thank you.
Mr. Siegel?
Good morning, Your Honors. May it please the court. My name is David Siegel. I'm here today on behalf of Vivian Brown. The FOID card requirement is applied to Vivian Brown, a person who is not prohibited under state or federal law from possessing firearms for self-defense in her home, is an unconstitutional infringement of Ms. Brown's Second Amendment right to armed self-defense with a long gun in her home. One's home and hearth is a location that is at the core of the Second Amendment right, which the United States Supreme Court in Heller elevated above all interests. The Supreme Court reiterated this in McDonald versus City of Chicago, when it held that the inherent right of self-defense of self, family, and property is most acute in the home. Counsel keeps has referred to this as a de minimis, the FOID card requirement under 430 ILCS 65/2A1 that requires a state license for what the state calls a privilege, but is in fact a constitutional right. They require a license to do that, and there's criminal penalties if you fail to comply. The first violation is a Class A misdemeanor, and if you do it again, now you're a felon and you become a prohibited person. So the burden is not de minimis and the effect is not de minimis. It is not quick, it is not easy, and the fee, at least to some, if not many, is not nominal, if it's allowed at all, which Ms. Brown asserts it is not. Not only that, it doesn't work. It's duplicative. It's overbroad. As Justice Burke noted, it casts a very wide net that sweeps all law-abiding persons in the state into it. And the practical effect, if one looks logically at it, If you're a law-abiding person, you have to comply with it. If you're not a law-abiding person, one of two things is going to happen if you apply for a FOID card. You're going to get turned down, in which case you're not allowed to possess a firearm, but you're already not allowed to possess a firearm under the state criminal statutes and the federal criminal statutes. The Section 922G of the Federal Gun Control Act, the aggravated unlawful use of a weapon by a felon statute. There's already laws on the books. And so that felon who applies, to use that, stick with that example that counsel kept putting forth, they're going to apply for a FOID card. And if they did, they're either going to get turned down, in which case they're exactly in the same position they already were in, or they're going to accidentally get a FOID card because the state's going to overlook the felony or miss the felony. And now it's the opposite effect. That felon has a gun license that the state has given them, and they're still a prohibited person, but now they have a license. So the effect of the state of what it claims it's trying to do, it either has no effect or it has the opposite effect. And for people like Ms. Brown, and who this is an as applied case as to her, she's swept up in a net for because of a situation that actually has nothing to do with her. The state says that there is no backlog, but the fact is for years, there has been a backlog. The pandemic made it worse, but it predates the pandemic. The application procedures, the appeal procedures, counsel didn't mention at all what happens when someone has their license revoked because they get a criminal charge, but then it's dismissed. Now they have to do an appeal, and maybe a year later they get their license back after having to hire an attorney, and maybe even having to go to court to enforce that appeal to get a ruling on it. That's why in the Northern District of Illinois, there's lawsuits going on currently over the FOID application process and the FOID appeal process. This is not quick, and it is not easy. It is not nominal, and it is a large burden on law-abiding persons like Ms. Brown. The circuit court held succinctly that the FOID Card Act is not substantially related to an important government interest, and said that any fee associated with exercising the core fundamental constitutional right of armed self-defense within the confines of one's home violates the Second Amendment. I'm going to talk in a second about why this case implicates the Second Amendment and why, whether one looks at the principle under Cherez that the implication of the Second Amendment, i.e. step one of the two-step process, should be presumed, and we should move on to step two, but also why it's implicated on its own. But the fact is that it is implicated. The state argues that the FOID Act aligns with Heller for keeping the mentally ill and felons from getting guns. But as I noted, there's already state and federal laws against that. And if the state feels that that category is too lax, it can pass more targeted laws for those things. But what the FOID law does is creates an entire new category of criminals. And that includes Ms. Brown. Now, the Umholtz amicus brief is somewhere in the range of 50 to 60 pages of how long gun regulations did not exist in the framing era. In fact, it was the opposite, that all the ratifying states of the Second Amendment required firearm possession. The only licensing laws that existed for long guns back in the the framing era were explicitly racist. It is really nothing that that the state should want to hang its hat on, and it is nothing that the court today should hang its hat on. Long guns were mandated for militia service, and the Heller 2 court noted that requirements of newer vintage are not presumed to be valid, thus falling within step 1 of the two-step process. Heller 2 noted that only the registration of handguns was longstanding, and that registration requirements for long guns were novel, not historic. The Heller 2 court also found that requirements that amount to registering the gun owner as opposed to the gun are novel and not historic or long-standing. And the fact that only 2 states, as one of your honors had noted, the fact that only 2 states have a requirement such that requires a license to possess a long gun in one's home should demonstrate the novelty of the restriction at issue here. Now, the state referenced the Heller 3 case, which upheld the long gun requirement as de minimis. It's an interesting situation between the difference between a civil suit and a criminal suit. Mr. Heller brought that suit, and Heller brought Heller 2, brought Heller 3, and on remand at Heller 2, the court said, and now I'm quoting from Heller 3, "We therefore allowed Heller during the discovery proceedings on remand the opportunity to introduce evidence that might differentiate the registration."
Yeah, Crow, I don't think you'd have to worry about 922R. 922R technically should only apply to importers and manufacturers, not to private persons. Matter of fact, when I started building AKs, I did a bunch of research into 922R and couldn't find a single case where a private citizen was either charged, convicted, anything under 922R. That's now, would I trust our ATF not to try to do some shit like that these days? Oh, hell no. They charge you for anything.
Buddy.
Requirement for long guns from other registration requirements that undoubtedly entail a de minimis burden upon a constitutional right. As the district court subsequently determined, however, Heller offered no evidence distinguishing the basic registration requirement as applied to long guns. Indeed, he did not even argue the point. I don't know why Mr. Heller didn't, or the other plaintiffs in that case, if there were more than one. I don't know why they didn't argue the point. I don't know why they didn't present evidence, but they were civil plaintiffs and they had a burden to do so. In this case, the state has a burden to present evidence to support
what's up,
its
my brother?
assertion in favor of the constitutionality, and they haven't done it. It is not Ms. Brown's burden to disprove this. It is the state's burden to justify it, and the state can't do it. The state attempts to frame the issue as one about felons and mentally ill, but Brown and those like her are neither of those things.
Abigail, what's up, sis?
And the FOID law was enacted in 1967. So whether the court looks to 1791 or 1868, I believe that 1791, ultimately the framers' view in 1791 is the more correct view. Even if you look to 1868, you should be looking to say, well, what did 1868 think about what the framers thought in 1791? So one way or another, wind up back at the same place. But the FOID law is from 1967. It is not long-standing under any analysis here.
AR, man, so I enjoy your
balancing means and scrutiny analysis is used or not. The FOID licensing regime is not grounded in text, history, and tradition, and is therefore not consistent with the Second Amendment individual right. The circuit court was correct when it found that as well. And then, of course, we have the Cherez case that presumes step one is met, that some level of scrutiny applies, and that we should go directly to step two, which is determining the level of scrutiny and applying whatever evidence or the state has to see if it meets the required heightened scrutiny. And when you do that, the state fails as well.
What level of scrutiny are you talking about?
It should be on any level. And tackleberry bugs on.
Level that chair is found based upon the sliding scale.
Well, I guess
tackleberry bugs
we're
look like it's got
talking
OG tank in there with it.
To some degree, we're talking about semantics because I think intermediate scrutiny is in and of itself heightened scrutiny.
Matter of fact.
But the Cherez court said that it's likened it to a sliding scale.
Tackleberry
So
in the chat
the
too.
more you're infringing on
Tackleberry
the
bugs
right,
looks like
the
looks
more
like he's
along
got
the
OG
scale
in there with
closer
it.
to strict scrutiny, and of course, the less infringing on the right. And so, what do we have here? The state wants to characterize as a de minimis, quick, easy thing, but we know it's not. So this is as the court noted, Justice Burke, I believe it was you that said it. You're taking the Second Amendment right, and the state is turning it into a privilege that a law-abiding person only gets to exercise at the whim and the largesse of the state. That is not right. It is infringement on all law-abiding persons, certainly all those in Ms. Brown's shoes, and therefore, when you're taking that sliding scale, I would move it much toward the heightened scrutiny, the heightened intermediate scrutiny, the near strict scrutiny of Ezel 1 in the Seventh Circuit. Also, the Solomon versus Cook County Commissioners case discussed this as well. The FOID requirement as applied to Brown fails the heightened scrutiny test, whichever one the court wishes to apply, under Cherez, Ezel 1, Ezel 2, and Heller 2. The state cannot defend its regulatory scheme with shoddy data or reasoning. The state's evidence must fairly support the state's rationale for its ordinance. There must be evidence to support the state's rationale for the regulations. Lawyers' talk is insufficient. I would put myself in that category of lawyers' talk being insufficient, but as I said, Ms. Brown doesn't have the burden here, the state does. Sheer speculation is not enough to satisfy the burden. And you look to the Cherez case again, even though public safety will always qualify as an important, if not compelling, government interest, the state cannot simply invoke those interests in a general manner and expect to satisfy its burden. That is all the state's doing here. What are they doing? They are mustering up old statutes that call for the confiscation of guns upon commission of certain wrongdoings, such as failure to swear a loyalty oath to the government or improper storage. But none of this has to do with the concept of a licensing requirement for home possession of long guns for self-defense. The state is throwing up, let me rephrase that. The state is putting out there to the.
All right, so I forgot I was muted. But that's what pisses me off about a lot of this and a lot of these arguments. There's nothing in the Second Amendment that says, well, you can't own guns in your home. There's nothing in the Second Amendment that says the government you have to prove to the government that you can own these arms. In a lot of ways, lawyers are killing this country. Lincoln himself pretty well killed the Constitution, and lawyers are just whittling away at it. Now, are there some good lawyers like this dude who are fighting against this stuff? Yes. But I think a lot of these things could be argued a lot better.
Court,
That's what I should
every
have
kind
done.
of regulation and
and
study it can find, such as handgun restrictions,
Should've been
purchase
ordered.
regulations, public carry regulations, age and race restrictions, because it doesn't have anything on point. And they're hoping that something sticks. Well, look at all the firearm regulations that are out there. Surely this one must be okay.
Yes.
So look at the cases that they're citing. Henderson, public carriage of a handgun by someone under 21 years of age, none of which has to do with this case. McGowan, a firearm storage case in Massachusetts that explicitly states the court explicitly stated it did not apply heightened scrutiny.
Anytime one of your rights is in question like this, there shouldn't be intermediate scrutiny, any preponderance of evidence. It should be hard and fast. This is what I'm making you spaghetti, buddy. Well, son's bringing me SpaghettiOs. But it should be, this is what the Constitution says. This is very simple. Your BS law doesn't fit into it, so you guys can go eat a bag of dicks.
It can't, it's not relevant to this case. Mosley, handguns by minors. Taylor, public carry. Delgado, handguns and pistols. Barron, as the state noted, it's a concealed carry case that the logic does not carry over to this case of long guns in the home. The studies that they put forth involve handguns and firearm purchasing. So the required close fit or substantial relationship has not been shown. The state does not have anything to support its supposed connection between requiring law-abiding persons wishing to possess a long gun in their home for self-defense to also possess a FOID card and the claimed government interest. The state is just asking you to assume that it is true. Cherez does not permit that, and the state has not met its burden under any heightened level of scrutiny. And the truth is that for the state's purpose, that's okay.
Yeah, 100%.
Because they have other laws on the books. They want to
100%.
keep felons from possessing firearms. They have criminal laws on the books. They have laws for domestic violence. They can pass targeted laws that leave the law-abiding person out of it.
That's something that a lot of people these days don't get because they've just never either been informed, they refuse to inform themselves. But the government doesn't grant any of these rights. The government was supposed to protect all of these rights. The Bill of Rights doesn't grant anything. It was a bill to say, okay, government, you cannot touch these. These are rights these are a no-no for you. But people think, oh, the Second Amendment, that gives us this right. No, it doesn't give a shit. It's supposed to make sure that the government couldn't infringe on it. Mike McClune, my brother, what's up?
They just haven't. They've just created this incredibly complicated, unwieldy system that ensnares law-abiding persons.
May I ask you a question?
Of course.
That's hanging out there too. If in fact this case were to be sent back for compliance with the court's order and the mandate of the court's order, and the case then went to the appellate court on the issue of the statutory argument, what would your position be there? What will you argue?
Justice Tice, I'm sorry, I want to make sure I understand the question.
Let's assume this case, instead of resolving this issue here, what this court does is send the case back as it did before And therefore, what we'd have would, and somehow vacate the motion to reconsider and the later findings by the court, go back to square one, where it was earlier. Therefore, there was a statutory basis for the court's decision, and I assume there would be an appeal of that, correct?
So we're talking about the supplemental issue, the
Yes,
briefing that
yes,
we're.
yes. What would your position be in the appellate court?
Ms. Brown couldn't have a colorable position until the state started saying, if you want to remand back on that, that's fine with us. I was actually in agreement with everything they had said and written on the issue.
So what would you, literally, what would you do if the state files an appeal? What would you file in the appellate court?
I guess I would have to come up with something that says along the lines of, Ms. Brown wasn't making this argument. This argument was sort of compelled upon her. She didn't make it in the circuit court. She specifically disavowed it in the circuit court. But since she's here, if the 5th District agrees with this court on the issue, well, this court didn't find anything on the merits.
We had a little discussion about an ethical obligation. What would your ethical obligation be in that situation in the appellate court? If you've stated that you disavowed that argument, what would your position be?
That my client has my client can't really feasibly defend the position. It's, as noted, it's not a grounds for a motion to dismiss under the statute. And in fact, she didn't even file a motion to dismiss under the motion to dismiss statute. It's more of an affirmative defense, but nevertheless, it was a dismissal. So I guess at best I would have to say something ethically along the lines of, if the 5th District agrees with the position of the circuit court in that original order,
Hey,
then
man,
we'll
don't
take
dismiss
the
yellow
dismissal and
cake.
Go home.
Uh-oh.
But
You would not
I see.
argue that the
What?
trial court was correct.
I don't think I could, with all respect to the court, because I know that some of the members
Zero
of this
respect
court
to this
wrote
court.
round one.
Yeah, sure.
So I don't want to say anything that sounds cheeky or glib.
Bobby.
But I respectfully, I don't see how I could legally defend the original non-constitutional order. I think personally that it was, it's incorrect legally. I think the 5th District would, after a couple years or a year or two, whatever, reverse, and that Ms. Brown would wind up right back in legal
Yeah, that
jeopardy,
doesn't surprise me, Warsaw.
which is why I believe that, I don't know how to pronounce this, Shizuski versus Gleason, CZYZEWSKI, 49 Illap 3rd, 655. Circuit Court's power of
And why have you got to give me
reconsideration
another
should be
case to
liberally
look up?
exercised in order to promote justice. That's why I think that, besides the reasons that counsel stated, why I think that
Still one or
the
two
circuit
other
court,
cases I'm looking at we got to
properly
listen
granted
to.
the motion to reconsider. Ms. Brown was just going to be in legal limbo for a couple years with a
Cool deal,
position
Ivy.
that
What are you?
she didn't want to make, and quite frankly, I don't know how she could defend. My
My
time
child.
is well up, but if there are any questions from
Thank you,
anyone else.
My child.
Thank you, Your Honors.
I haven't listened to this yet. I can't remember yet whether the state comes up there and gets a second kick at the cat on this one too or not. Yeah, here he is. He definitely hasn't been punched in the face enough.
Thank you, Your Honors. As opposing counsel noted several times, this is an as-applied challenge, and it does relate only to defendant and her specific circumstances, which, as he noted, is someone who keeps a long gun at home for self-defense. Nevertheless, my opponent's argument in some ways relied on burdens that he alleges can exist when the statute doesn't function in the fairly quick, painless way that it is intended to function. But there's, of course, no evidence that that is what happened to the defendant here, nor could there be, because she never applied for a FOID card. So besides the fact that if that were something the court wanted to
Monkey, that's not how that works.
best served remanding for development of some kind of evidence about how quick and painless the statute operates. It's just not applicable to this defendant who didn't apply for a FOID card. Turning to the merits of the specific argument,
I don't care. Honestly,
I think it's important to remember that courts often reason from analogy in
I want her
addressing
to like
the
somebody
prongs
on her
of
own
Second
terms, and
Amendment
not because she's
analysis
being
versus
brainwashed by that shit.
the question is not whether there was an exact analog for this statute
Dealing with my dad.
at the time of the draft. The question is whether this kind of regulation that allowed
She doesn't
states
know.
to keep track of and determine whether gun owners were in categories considered unfit or something that were familiar to the framers. And in that way, they plainly are. Similarly, while it is true that the empirical data discussed in the state's brief and in the Gifford Law Center brief relates to licensing schemes that
Of course,
often
Gifford is
differ
writing
slightly
briefs on this.
from the FOID card act, in that they apply, for example, at the time of purchase, or at the time of purchase, for example, are not exact analogs. The data that is culled from those studies is still telling for the efficacy of licensing schemes in general for keeping guns out of the hands of felons and misdemeanors. And we also have the experiential data from City of Chicago.
None of these
County that is
licensing
a
schemes have
tool for them,
stopped criminals
in
from
achieving
getting
this
guns.
end as well. Now, to the extent that that is data, that is secondary source social science research, as opposed to evidence that was introduced to a court, again, if this court feels that that's the distinction, then the proper step would be to remand and let the parties develop this data into evidence through testimony in front of the trial court. But the legislature is not required to build an incredible wall of empirical data in order to defend its policy decisions. Courts have repeatedly held, even in the context of heightened means and analysis, and even in the Second Amendment context, that the legislature and not the courts
Now,
are
Monkey,
best positioned.
Monkey had schedules earlier.
Policy
She's fixing to head to
determinations where
bed.
there is conflicting social science data. And while we believe that the data in our brief and in the Giffords brief establishes the efficacy of this licensing scheme, to the extent that defendant has presented contrary data, that doesn't mean that the statute's unconstitutional.
Agorizer, what's
That means
up?
that the court should defer to the legislature, who is best positioned to make these determinations, to have answered the question that, yes, based on what it knows, this was an effective way to
Shit, they can't
pursue,
stop criminals from getting guns
important
in jail.
government interest.
You presented the evidence that you thought was relevant and appropriate in the trial.
What you
court in
want?
support of this law, correct?
What do you want?
Well, so it was, again, this is one of these situations where, because it was a criminal prosecution.
Hold on, Wubba,
and
Daddy,
not
fix your bowl.
a sort of typical civil litigation.
Daddy, fix your bowl.
Issues are resolved under. This was a pre-trial motion to dismiss the indictment. The state's position was both that because this didn't implicate protected Second Amendment conduct, and because there was empirical data sufficient to support the efficacy of the program if you did move to the second
Oh,
step.
hell yeah.
That was enough, given the presumption of
Breakfast for
constitutionality
dinner
of statutes, for the court
is
to
usually a
conclude
good
that
choice.
This statute was constitutional as applied to defendant. I'm merely saying that.
Yeah, even my
if
wife was going, uh-huh.
the court, I think this is very different than Chera's, where the state was referencing the general ideas
breakfast
of
for
public
dinner is
safety,
shit.
but not really
Then you can have
drawing
wine for breakfast.
any kind of connection between
Yeah, Abigail, and they
the
were
data about the danger of
forever
guns
in the United
and
States.
keeping guns out of this specific
Until
location.
68,
This
actually.
is a situation where the empirical data does draw a direct connection between licensing schemes and keeping guns out of the hands of dangerous groups. So I think it's sufficient to find a substantial relationship between the means and the ends here, even if the court does move to the second step. But if the court feels that further development of evidence in support of or against the efficacy of the statute would somehow serve that analysis, there are opportunities to develop that evidence. But ultimately, Your Honors, this case isn't about a law-abiding citizen who had her right to possess a firearm at home for self-defense restricted. By her own admission, this defendant didn't abide by the law. She didn't apply for a FOID card. If she had, and if she was eligible for one, then she would have received a FOID card. This isn't at the whim of the state. The statute is very clear that you get a FOID card unless you are not, unless you fall into one of these substantively unqualified categories. And since we know that these substantive restrictions do track the ones that courts have repeatedly held are constitutional, you get a FOID card if you are constitutionally guaranteed this right to have a firearm at home for self-defense. She didn't take those steps. And that's why she got in trouble. The burden of criminal liability doesn't arise simply because the FOID Card Act exists. It arose because she'd never applied for a FOID card and possessed a weapon without having taken these steps. And for that reason, and all the reasons we've discussed in our briefs and in this argument, this court should hold that the FOID Card Act is constitutional as applied to this defendant who kept a firearm in her home without ever having applied for a FOID card. And unless the court has further questions, we would ask that the court reverse the judgment of the circuit court.
Thank you, Mr.
Thank you, Your
Fisher.
Honors.
Case number 127201, People of the State of Illinois versus Vivian Claudine Brown, taken under advisement as agenda number 5. Thank you, Mr. Fisher, for your arguments this morning. I guess it's still morning. And also Mr. Siegel. Thank you very much.
All right, so I'm back. Six-round launcher a few years ago, 15K. Yeah. I had my hands on an MG34 not too long back. $8,000. It was a Croatian. Yeah, it was a Croatian build. But yeah, $8,000.
Why got the camera pointed so you can see me stuff in my bag?
You're sitting there. This is the way my camera always points. So, nah. Yeah, man. Keep sending. Will you?
I missed.
You
How
better,
the fuck did I miss
better
that
not
big
be
ass
throwing bread.
Speech of garlic bread. How the fuck did I miss
You
that
deserve
big
your ass kicked just for throwing garlic bread.
You know what I wait for to get this shit?
That's why another reason you did your ass kicked for getting it. Don't.
The fuck I want to it.
It's your language around that child. All right, guys. So I'm going to end this one here. I'm sure we got more cats going live right now. Jesse James losing me here. Oh, yeah, dude. Jesse James is building some beautiful guns.
Did I tell you we had Don King in the shop?
No, you didn't tell me you had Don King in the shop. All right. I guess that's another story.
I'll tell you. It's really simple.
Yeah, dude. And G23, if you're still in here, man, anything you can send me on Oregon, send it to me. Because we'll get together and we'll do some streams on that stuff too. Because that ballot measure 114 is another just absolutely insane. That's funny, Abigail. All right. So anyway, perps, I am out of here. As always, you perps be cool. Keep that thing on you at all times. And as soon as we can crank another stream, we will crank another stream. G23, yeah, man, send me any links you got on that stuff in Oregon, and we'll do some streams on it. Even if we do them later, and me and you can get on the stream together, we'll do them that way. Because that, like I said, that 114 something, I really, if there's anything on that, I want to cover it. Just like when they come through with the rest of the shit on pistol braces and all that. Which, I mean, it's one of the reasons I'm covering FOID card stuff. So, anyway, you perps take them easy, be cool, keep that thing on you at all times. Send it to me, G2. Just email it to me, brother, if you can. If not, I'll look it up. I mean, it ain't no big deal. I'll try to find it. But anyway, guys, I'm out. I'm fixing to go give me something to eat and probably watch a couple of shows. So you guys take them easy, man. Later.